All right, welcome back to the Daily Facts. And we're going to read through the lawsuit for Carter Page. First, let's just read the top here. Case 1 colon 20-CV-03460. And this was filed on November 27th of 2020. United States District Court for the District of Columbia. So Carter W. Page is the plaintiff versus James Comey, Andrew McCabe, Kevin Kleinsmith, Peter Strzok, Lisa Page, Joe Pienka III, Stephen Soma, Brian J. Outen, Department of Justice, Federal Bureau of Investigation, United States of America, John Doe's 1 through 10, and Jane Doe's 1 through 10. And I think it's important to point out here it says jury trial demanded. Okay, so he wants a jury of his peers. Carter Page does. All right, so let's go ahead and get into it. Complaint. On November 10th, 2020, defendant Andrew McCabe testified in front of the Senate Judiciary hearing that any material misrepresentation or error in a FISA application is unacceptable, period. The FBI should be held to the standard of scrupulous accuracy that the FISA court demands. When pushed to explain who is responsible for ruining Mr. Page's life, McCabe finally responded, "We are all responsible for the work that went into that FISA." This lawsuit seeks that accountability and damages against the individuals and agencies who wronged plaintiff Carter W. Page, Dr. Page. Specifically, Dr. Page seeks relief herein for defendants' multiple violations of his constitutional and other legal rights in connection with unlawful surveillance and investigation of him by the United States government. Dr. Page was targeted because of his lawful association with the 2016 presidential campaign of Donald Trump. Dr. Page is entitled to relief for defendants' unjustified and illegal actions, including violations of federal criminal law, which violated federal statutes enacted to prevent unlawful spying on United States persons, as well as the Constitution. The complaint or misconduct occurred in connection with the submission of 4 false and misleading warrant applications to engage in electronic surveillance of Dr. Page, ostensibly pursuant to the Foreign Intelligence Surveillance Act, FISA. 4 separate Article 3 judges unwittingly approved the false applications submitted in October 2016, January 2017, April 2017, and June 2017, thereby unlawfully resulting in spying on Dr. Page. As has now been admitted by the U.S. Department of Justice, DOJ, and the Federal Bureau of Investigation, FBI, and or has been acknowledged by the Foreign Intelligence Surveillance Court, FISC, the 4 separate applications for FISA warrants and renewals, collectively the FISA warrants, to surveil Dr. Page were submitted despite there being no probable cause to suspect that Dr. Page was acting as a foreign agent of Russia. Consequently, the defendants' unlawful actions allowed them to illegally spy domestically and internationally on Dr. Page, a patriotic American citizen. The defendants' conduct, which began not later than August 2016 and continued through at least September 2017, constituted a fraud on the FISC and violated the constitutional and other rights of Dr. Page. Overview of the violations. On July 31st, 2016, the FBI opened a counterintelligence investigation named Operation Crossfire Hurricane, putatively concerning the Foreign Agent Registration Act, FARA, to determine whether individuals associated with the Trump campaign are witting and or, before we continue, let's read this footnote. It's one from the above. For clarity, the four separate FISA warrants, when discussed individually, are referred to herein in the order of the application submitted to the FISC. For example, the October 2016 FISA application is the first FISA warrant, and the first renewal submitted in January 2017 is referenced as the second FISA warrant, while the April and June 2017 FISA renewal applications are referenced as the third FISA warrant and fourth FISA warrant, respectively. All right, let's continue. Coordinating activities with the government of Russia. Soon thereafter, Dr. Page and three other individuals whom he had little or no relationship were targeted by the FBI in the Crossfire Hurricane investigation. The FBI investigation soon devolved into an effort to obtain from the FISC a FISA warrant authorizing spying and electronic surveillance on Dr. Page. The FBI did not have probable cause to lawfully obtain a FISA warrant. Instead, the FBI used documents furnished by Christopher Steele, a confidential human source, CHS, as the Crossfire Hurricane team knew. CHS Steele had been paid by the Democratic Party and or the Hillary Clinton presidential campaign to perform political opposition research, and that's in quotes, and dig up dirt on a connection between the Trump campaign and Russia in order to divert attention from the investigation of Clinton's email practices while she was Secretary of State. In accordance with core principles of the U.S. Constitution, reinforced by the nation's legal and cultural aversion to spying on its citizens, Congress and the executive branch have enacted rigorous requirements that must be met before electronic surveillance of a U.S. citizen is legally permitted. To surveil an American citizen, the FISA requires that there be probable cause that the target is an agent of a foreign power who is knowingly engaging in clandestine intelligence activities. In short, to legitimately obtain a FISA warrant against Dr. Page, the FBI had to demonstrate that he was a Russian agent who was knowingly engaged in intelligence activities on behalf of Russia. On August 17, 2016, shortly after the inception of the Crossfire Hurricane investigation, the Central Intelligence Agency, CIA, provided information regarding Dr. Page to members of the Crossfire Hurricane team. This information established that Dr. Page had been a CIA operational contact from 2008 to 2013 and had similar interactions with the FBI. Dr. Page had assisted the CIA in combating intelligence-related activities pursued by Russia and other foreign countries against the United States' interests. Further, the CIA's employees had given a positive assessment of Dr. Page's candor. Further, on September 7, 2016, the CIA sent an investigative referral to FBI Director James Comey and Deputy Assistant Director of Counterintelligence Peter Strzok, advising them that Hillary Clinton had approved a plan concerning U.S. presidential candidate Donald Trump and Russian hackers hampering U.S. elections as a means of distracting the public from her use of a private mail server. Letter of Director of National Intelligence dated September 29, 2020. During this investigation, the same investigation phase, the FBI used a second CHS to surreptitiously ask Dr. Page about his activities. In this monitored conversation, Dr. Page denied that he either I knew anything about improper, unlawful communications or activities between Russia and American citizens, or had engaged in any improper, much less illegal, activity with an individual that was harmful to the interests of the United States. This conversation was recorded without Dr. Page's knowledge and was provided to the FBI. On September 19, 2016, as referenced above, the FBI received information regarding Dr. Page from CHS Steel, in particular, two documents prepared by CHS Steel falsely alleged unlawful communications and activities involving Dr. Page and two Russians with close ties to Russian President Vladimir Putin. The FBI focused on these two documents from Steele to base its claim that there was probable cause to obtain a FISA warrant against Dr. Page. On September 23, 2016, an article was published in Yahoo News alleging meetings between Dr. Page and the same two Russian individuals. The FBI treated this article as cooperation for CHS Steele's claims when, in fact, Steele was also the source for the Yahoo article. Further, on September 25, 2016, Dr. Page sent a letter to then FBI Director Comey in which he categorically denied that he had any such communications with the Russian individuals and documented his previous cooperation with the CIA and FBI to combat Russian spying. These false allegations against Dr. Page made CHS Steel were not investigated by the FBI in accordance with its own manuals and procedures. For the FBI to disregard its procedures was particularly egregious in this case because the FBI knew that CHS Steel, A, was being paid to provide political opposition research on this topic, B, was essentially the exclusive source of information supporting probable cause for the FISA warrant applications, and C, the CIA had warned the FBI of a potential political scheme involving false reporting of collaboration between the Trump campaign and Russians. The more fundamental problem was that the FBI was so intent on obtaining a FISA warrant to enable it to spy on the Trump campaign that it did not fully and accurately disclose to the FISC the evidence it had obtained as to whether Dr. Page was a Russian agent. To persuade the FISC that there was probable cause to believe that Dr. Page was a Russian agent, the defendants provided false or misleading information to the FISC. The FBI did not advise the FISC that Page had been for many years an, quote, operational contact of the CIA, end quote. The FBI did not advise the FISC that CHS Steel had The FBI did not advise the FISC that Page had been for many years an, quote, operational contact, end quote, of the CIA. The FBI did not advise the FISC that CHS Steel had been paid by the Democrat Party and or the Clinton campaign to provide opposition research on Donald Trump. The FBI did not advise the FISC that Steele's primary subsource of information against Dr. Page had himself been investigated for attempting to recruit Americans to help spy for Russia. The FBI did not advise the FISC that Steele's primary subsource contradicted critical information that Steele attributed to him. Instead, the FBI represented to the FISC that the primary subsource was credible without disclosing to the FISC that the primary subsource had credibly reported to the FBI was the information Steele attributed to him was accurate and misleading. Ultimately, an FBI attorney altered an email from the CIA in order to falsely deny that Dr. Page had been a CIA source serving for many years as an operational contact. In reality, there was no probable cause to support surveillance of Dr. Page. If FBI procedures had been followed and an honest and thorough investigation conducted, and if the FBI had fully and accurately reported what it knew, the FISA warrants against Dr. Page would neither have been sought nor issued. The individual defendants fabricated or intentionally disregarded critical evidence and misled the FISC in order to obtain the FISA warrants. This case is about holding accountable the entities and individuals who are responsible for the most egregious violation and abuse of the FISA statute since it was enacted over 40 years ago. Parties. Plaintiff Carter W. Page is a natural person who is a United States citizen. Dr. Page is a graduate of the United States Naval Academy who served on active duty in the United States Navy, including deployments at sea and other assignments worldwide, many in intelligence-related billets. From 1993 until 1998, reaching the rank of lieutenant. After completing his active military service, Dr. Page served as an International Affairs Fellow at the Council on Foreign Relations and focused his research on energy-related developments in the strategically important Caspian Sea region. Dr. Page earned a Master of Arts degree in National Security from Georgetown University while on active duty, and subsequently completed the MBA program at New York University, NYU, in 2001. This led to a position as an investment banker with Merrill Lynch. Dr. Page eventually became the chief operating officer of Merrill Lynch's Energy and Power Group in New York in 2012. In New York. In 2012, Dr. Page was awarded his PhD degree from SUES University of London, School of Oriental and African Studies. He ran the Globalization and International Affairs program at Bard College in New York and subsequently returned to NYU to teach courses on energy and politics. During the 2016 U.S. presidential election, Dr. Page was a volunteer member of an informal foreign policy advisory committee to then candidate Donald J. Trump's election campaign. Although a campaign volunteer, Dr. Carter never met or spoke to then candidate Trump. Entity defendants. Defendant United States of America is sued for Dr. Page's injuries caused by the wrongful acts of its employees acting within the scope or office of their employment. Defendant Federal Bureau of Investigation is a bureau within the United States Department of Justice with offices at 935 Pennsylvania Avenue, NW, Washington, D.C. 20535. References to any actions taken by FBI in this complaint encompass its officials, appointees, employees, agents, and or contractors, both known and unknown to plaintiff. Defendant United States of Justice is an executive agency of the United States with offices at 950 Pennsylvania Avenue, NW, Washington, D.C. 20530, and includes its Office of Inspector General, DOJ OIG. References to any actions taken by DOJ or DOJ OIG in this complaint encompass their officials, appointees, employees, agents, and or contractors, both known and unknown to plaintiff. Individual defendants. The individuals named herein have responsibility and liability for the legal claims identified herein, as set forth above and below. In addition, individuals as yet identified or unknown to plaintiff are also responsible and liable for the legal claims set forth herein because of the clandestine, classified, or law enforcement sensitive, protected nature of the actions taken in pursuant of the Crossfire Hurricane investigation and the FISA warrant applications and the protection given to the identity of individuals by the DOJ OIG in the Horowitz report. Plaintiff is as yet unable to identify by name these additional individuals. Defendants James Comey was the director of FBI from September 2013 to May 2017. Defendant verified under penalty of perjury 3 false FISA warrant affidavits regarding Dr. Page in October 2016, January 2017, and April 2017. He was dismissed by the President of the United States on May 9, 2017. He is sued in his individual capacity. Defendant Andrew McCabe was the deputy director of the FBI from February 2016 to January 2018. He was an original and primary participant in the Crossfire Hurricane investigation. Defendant McCabe was the FBI's legal signatory of the final FISA renewal affidavit against Dr. Page in June 2017. He is sued in his individual capacity. Defendant Kevin Kleinsmith was an assistant general counsel in the National Security and Cyber Law Branch of the FBI's Office of General Counsel from July 2015 to September 2019. In August 2020, Mr. Kleinsmith pleaded guilty in the United District Court for the District of Columbia to a false statement offense based on intentionally altering an email in connection with the submission of the FISA renewal application against Dr. Page. DOJ press release August 19, 2020. See information USA versus Kleinsmith, number 20CR0015165 DDC, August 14, 2020. He is sued in his individual capacity. Defendant Peter Strzok was a career FBI agent until August 2018 and served as Deputy Assistant Director of Counterintelligence. He supervised the investigation of Dr. Page until approximately January 2017. He is sued in his individual capacity. Okay, we're going to leave it there, and we'll pick up next time. Thank you for stopping by the Daily Facts. Do like, share, subscribe, and leave a comment below, and we'll talk again soon. Bye.